insist my spouse update their will? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to talk about an interesting question that I saw come up in the weekend paper. And that is, can you actually force your spouse to update their will? Now the exact question went like this. So a woman had married a man, and apparently before they got married, the man was a little bit older than her, and he had created his own will and his own estate plan back in the day, leaving his assets to his other family members. Since the time that the will was signed, he's obviously gotten married, and now he and his wife have a child. So the question from the wife is, can she force him to update his will? Because see, what's been happening is she's getting a little nervous about these things. She wants to make sure everything's in place, everything's updated. She's asked him a few times, and he said, yeah, I'll get around to it. But so far hasn't done the work to get the estate plan updated, and she was worried that if something happened to him tomorrow, would she be entitled to inherit anything from him, and would it leave herself and her daughter without a home? So when people come to me with this question, the main question usually is, when should I be updating my will? And the simple rule of thumb is when there's been a major event is when it's probably a good time for you to update your will. So for example, if you get married, it's usually a good time to update your will. If you have children, if your children graduate college, if your children get married, if you have grandchildren, or if you're moving to an entirely different state, these are all good reasons for you to consider updating your estate plan. Now, these major life decisions don't always make you have a new estate plan. For example, you can have an estate plan that you create when your child is young, and it can be good for another 30 or 40 years. It doesn't become invalid because of these major life events, but you may be missing out on advantages you can take by updating your estate plan when one of these big events happens. So for example, when you get married, we want to make sure that your estate plan is updated to reflect that you now have a spouse, especially in the healthcare document field. You want to make sure that your spouse, if you want them to, can make major medical decisions for you if you become incapacitated for some reason. Now, if we look at children, whether children are born, whether they graduate college, whether they get married, all of these major events with the children can have effects on your estate plan. When they're born, we want to make sure we're adding them to your will, and we want to add a guardianship provision as well and a trustee provision as well, so that if something happens to you and your spouse, and your child is under the age of 18, we know they're protected. Once those children now graduate college or they're done with their education, they're adults now. We definitely don't need the guardianship provision if they're over 18, and we may not need a trustee provision either. However, some people will actually hold that money back and have the trustee be in charge of that money until the child hits the age of 25 or 30. You don't have to do it that way, but that's something to consider when that child finishes their education. Same thing when your children get married. You want to look at, is it now a good time to update the estate plan if you had certain bequests going to them, now that's going to them as a married couple? You may have different reasons for giving them money at that point. And then, of course, if grandchildren are born, it's a great time for you to relook at your estate plan. There's a lot of advantages you can take. Using an estate plan and even leaving money directly to your grandchildren. You can leave a legacy another generation down the line from where you are right now. And then, of course, if you're moving, the question is, how far are you moving? If you're moving down the street, you don't necessarily have to update your estate plan. If you're moving to a new state, though, you want to make sure you're at least meeting with an attorney in the new state to find out if there would be any advantage to updating your estate plan to a local estate plan, a local will where you are. It probably will be helpful when it comes to healthcare documents, though, because each state has their own forms. So we've looked at some times when it's a good idea to consider updating your estate plan. The facts that were given in this question, though, also have a couple other issues that you can think of. The first one being what's called the elective share. So depending upon what state you're in, your state may have what's called an elective share. The elective share is a statute that says if a spouse specifically does not leave any money to their other spouse when they die in a will, the surviving spouse can actually go to the court and elect for a portion of the estate. It can be up to 50% in some states. It can be some states have a table of what you can actually inherit. But that elective share is one reason why the questioner in our question for today may not have to worry too much, because if they're in a state with an elective share, then that may at least entitle them to half of the assets before the will is probated and the rest of the assets are divided. The other thing you can look at, the second thing, is beneficiary designations. So even if you have a will and you say, oh, I don't have the time to update it, it's too complicated, a simple way to update your estate planning documents is to make sure your beneficiary designations are up to date. So if you get married, you can now add your spouse as your primary beneficiary. Let's say you have kids. We've had another big change. You can now make them your secondary and your third beneficiary. Your grandkids can be your third level beneficiary. But when we do a beneficiary designation, they're going to pass outside the terms of the will. So that if you're really worried about updating that will, but most of the assets are things like life insurance and retirement accounts with beneficiaries, the will may not be the thing you're really concerned about updating, and maybe you want to make sure your beneficiary designations are updated. So I've given you a kind of a lot of information coming out of a really short question of, can I force my spouse to update the will? So there's two ways you can approach this whole situation. One is you can try to do this yourself, but chances are if you're looking at videos on the web, you're knowing that this is probably not the area you want to try to do it yourself. The second way to do it, the smarter way to do it, is meet with a professional. So talk to your local attorney about whether it's a good time for you to update your estate plan. If that spouse of yours won't go with you, go to the meeting, meet with them, get all of the information, and that attorney can probably give you 3 or 4 good reasons why your spouse had better update that estate plan immediately. And if you're moving to a new state and you aren't sure whether your old estate plan is going to be good or you need a new one, then sit down with a local attorney. They can tell you, for example, if you're moving from New York to California, we have very different property rules in those 2 different states. And any of my clients from New York who move to California, I always tell them to meet with a California attorney and make sure their documents are set up the way they should be. So if you're ready to get started, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the front page. Click it and you'll be taken to my personal calendar. We can set up a 15 or 20 minute phone call to discuss the best options for you and your family. We may not be able to force that spouse of yours to sign the documents, but we can probably do everything short of dragging them to the office kicking and screaming and putting a piece of paper in front of them and making them sign it.